The protection of workers has come a long way in Ireland. There was a time when dock workers and farm labourers would wait on street corners to see if they get a day's work. Thankfully, because of Ireland's membership in the EU and our domestic legalisation, there are now protection laws to make sure that workers have rights. One of the most important pieces of legislation is the Unfair Dismissal Act of 1977. It is not a court but provides employees with the right to state that they believe they were unfairly dismissed.
The Unfair Dismissals Act was introduced in 1977, and the reason put forward in Dáil Éireann at the time was that one of the problems in regards to the termination of employment of workers was the high incidence of unofficial action. In other words, if an employer unilaterally decided today to sack somebody, they had no protection. So what workers would do is immediately down tools and stop work. So that would have been one of the reasons cited. What it would have done, in effect, was give workers proprietary rights over their job.
If you're dismissed from your employment, you may, under certain conditions, bring a claim for unfair dismissal against your employer. In Siptu College on the South Circular Road in Dublin, they have been educating worker representatives on the complexities of employment legislation for many years. Norman Croke, who's the head of the college, says taking a case is a straightforward procedure.
What you do is, in your first port of call under the Unfair Dismissals Act is to a rights commissioner. You simply fill out a form, and the rights commissioner will hear the case. However, if the employer refuses to attend a rights commissioner, then it must go to the EAT, that is the Employment Appeals Tribunal.
In certain circumstances, in particular pregnancy, there can be several options. For instance, if a woman is dismissed due to pregnancy or having recently given birth and she only worked in company for less than a year, is she still able to claim unfair dismissal?
You have a multiple choice. You can take, for instance, the 1990, I think it's 1994, maternity legislation, which discriminates, which outlaws discrimination on the grounds of maternity, and you can take proceedings against your employer under that legislation. Or you can take proceedings against your employer under the 1977 Unfair Dismissals Act. Or you can take proceedings against your employer under the 2004 Employment Equality Act. What you would have to do is study each piece of legislation to find out which gives the most significant benefit.
What had started out to be handled by trade unionists often now involves lawyers. This can be costly, with regard to the loss of compensation.
The significant non-legal aspects of the 77 Act and its subsequent amendments was the introduction of the legal profession as advocates of workers. And for instance, if a worker's not in a union, in many instances, although it is not required, they can be represented by a solicitor or by a barrister. If you're represented by a solicitor and a barrister, as distinct from a trade union official, even if you win compensation, it can cost you more to pay the solicitor and the barrister for their interventions. It has also brought about what we call the tribunalisation of the whole legislation through the introduction of solicitors and barristers primarily represented by employers. One of our responses, even for instance, in Siptu College, was the development of our own employment law and industrial relations courses, where people are now competently trained, not only in the jurisprudence of employment, but also in the precedent cases, both within the Irish jurisdiction and in the European jurisdiction, because in many instances the precedents that you may refer can be European Court of Justice decisions in regards to